Thank you. If I can ask all the panelists to come back up and join so we can have some questions from around the room. And, we're going to pose these. I suspect some people will want to pose them to particular panelists. And Mark, thank you for being willing to participate on this as well. But generally, I want you all to feel free to chime in and interact with one another on all of these questions, because I suspect that there could be strong opinions out there on any given one of these. So I want to start with the fair information practices. And we had a bit of discussion in the early part of the day about sort of how much we tend to rely on consent, and yet it tends to fail us in terms of, I'm summarizing here and obviously drawing some potential conclusions from what I heard this morning, which you can feel free to push back on, that it doesn't always work as well as we would hope to protect patients. And then we've also heard a bit about de-identification as a methodology that we seem to rely on a lot in this space. The law tends to rely on it a lot. And yet there are all these other fair information practices, as Bob presented, that are represented in the law to some extent, yes or no. So what I'd like to get some feedback on is how can we sort of take all of that together in terms of what works best, what doesn't work best. What can we draw from fair information practices in the context of reuse or secondary analysis of clinical trial data in terms of a capacity to move forward? And that would be not just being in compliance with the law, ideally, if there's a way to do that, we want to hear it, but also we want to do this ethically and responsibly in a way that patients trust, ideally, I think. So having some feedback on that would be great. And since I drew from FIPS, Bob, if you could start, that would be great.
Well, I want to make a couple of points. One, what I said before, the biggest problem with disclosure is when you disclose stuff out of HIPAA to a researcher or a public health agency or certain other lawful recipients, the information is not subject to HIPAA. It is not subject to any privacy rule. And I think the research community, the records research community, doesn't pay enough attention to privacy and security and doesn't fulfill its obligations to protect the data and make sure that there are rules in place. Secondly, with respect to informed consent, I heard the discussion this morning, I wasn't here yesterday, about informed consent. A very traditional view. The healthcare system, as everybody knows, is changing in a major way. We are getting electronic health records. There's probably somewhere today, this month, another committee somewhere in the Beltway talking about patient empowerment and patient involvement in healthcare and patient access to their own records and how that can be used to improve the healthcare system. That access can be used in the informed consent process. There is no reason why we have to rely totally on IRBs to speak for patients or for the public. We can find people now or we will in the near future, we can find them through the electronic health record system and we can ask them whether their use of records is good or not. Now, there are a lot of reasons why you don't want to do that, and I recognize that that's an issue, and we can make a decision as a society that we really haven't come to, at least not in the current context, of saying we don't care what people think, we're going to use their records anyway. It's a legitimate argument. It will fail in the political marketplace when presented with the right kind of research. It's guaranteed to fail. But we can use the systems that are being developed to contact patients and find out what they want to know. If a high school student wants to use my record in a statistical study, I want to know who that student is. I want to know if it's my nephew or my neighbor's nephew who's going to be looking at the record as opposed to someone I don't know in some distant community. I think I need to know that. I may want to know who are the people involved in doing any kind of research. I want to know if it's someone I know, or if they will share. I worry about they will share the information with a neighbor. I think there's a lot of facility in this system that needs to be built in, and there's a lot of possibilities, and I think they need to be explored by this committee.
Anybody else want to answer the broad question I started with, or react to Bob's? Bob, does it matter to you if the data's been de-identified by Brad?
Yeah, I think that's a distinction, and I think we have to recognize the limits of de-identification. And I've suggested in a law journal article a proposal for a statute that would add a layer of accountability that's missing now when data is transferred, supposedly de-identified, but you never know, and would allow for data to be shared under a contractual framework. This would work for a lot of data, whether it's de-identified or not, where there's accountability provided of all different types. And people could opt into this, and this would encourage the availability of data and the sharing of data because it would provide protections for everyone in the system.
So the notion of open government, for instance, and open access is something that plays in somewhat of a parallel here. In many ways, we want to have greater understanding of what's going on in the systems around us and what people are doing. And at the same time, and there are lots of people who are putting data out there about themselves. At the same time, when the data is collected for a particular purpose, and it's stated up front that this was the purpose, and now it's going to be used for other purposes, this needs to be made known to the individual. How exactly you do this, I think that's a debatable issue, or it could have further discussion. However, the fact that it's a trick in that you need to understand how people will respond to misuse of this information, and at the same time, you have to know what this definition of misuse is. And I think right now there has not been a lot of precedence for the misuse of these data sets, and we don't know exactly what they will be. So the reason why I bring this up is that in many ways you can make a decision about what's the best way to ensure accountability or what's the best way to protect the information, but until we actually see what these misuses are going to be, it's extremely difficult to provide recommendations in terms of protections.
Dave?
Yes, I want to be clear about your comment, Bob. You said that the NIH is exempt from HIPAA by law.
I wouldn't put it that way. They're not covered because
Okay.
they're not a covered entity because they don't bill for their services.
So if I do a clinical trial that NIH funds, and I complete the trial and I send the data to the NIH, which might be a standard thing to do, is that data covered, or?
Well, the question is whether you're covered by HIPAA when you conduct the trial.
Yeah, presumably we are.
If you are, you can share the data with NIH if you go through one of the relevant provisions of HIPAA that allow you to share data. That data, whether you gave it to NIH, if you gave it to them as a research disclosure, whether you gave it to NIH or to me, it would still not be subject to HIPAA because once you disclose HIPAA data in that fashion, it is no longer subject to HIPAA in the hands of the recipient.
It would be subject to the Privacy Act, though, just so you know.
Artie?
So could I actually didn't have this as a question, but could you specify how the Privacy Act differs from HIPAA? And then I have a question for Barbara.
Barbara, no, you go ahead. You go ahead and answer.
Well, the Privacy Act.
Mike, yeah, Mike.
The Privacy Act basically is an act that governs data that's held by administrative agencies, and it has some restrictions and processes they have to do before they can disclose it, and it favors, not releasing the identifiable information and has a mechanism so people can have notice of what data is held about them. HIPAA, on the other hand, is a government regulation of private entities that are in the healthcare business.
Right, but the question that I had more specifically was, it sounds from what Robert was saying, that the Privacy Act is much more liberal than HIPAA. Is that true, or is that?
I wouldn't say that. What do you think? I just don't.
No, I mean, it's altogether like a sort of a different thing because it's really trying to shield individual information that's held by government agencies, and so it actually doesn't really allow government agencies simply sort of willy-nilly to release data, and so it's not particularly. It's not that it's different. It's different in orientation. It's different. It does not have, for example, let me put it this way. HIPAA, the way it's drafted, it's not a set of goals. it is a set of excruciatingly detailed it's a Stalinist method. If it's not permitted, it is forbidden, right? The Privacy Act is a more normal and typical American rulemaking, which is you cannot do this unless the following things happen, right?
Can I disagree with that somewhat? The Privacy Act, first of all, is based on fair information practices. All of them are in there. Secondly, the Privacy Act gives patients, individuals, greater rights of access to medical records than HIPAA does. HIPAA has a bunch of exceptions that are not available. The Privacy Act has amendment requirements that go beyond those, accounting requirements, disclosure history requirements that go beyond those in HIPAA. And there is a procedure under the Privacy Act whereby agencies can, by publishing a notice in the Federal Register, authorize any disclosure that they want. There's a statutory standard that nobody pays attention to, whereas HIPAA has a bunch of standards that are there, and for them to be varied, HHS has to go through a major rulemaking. So they're good things and bad things if you compare the laws.
Artie, also, just to note, when you're dealing with a specific agency, such as data held by FDA, they often have implemented regulations that implement their compliance with the Privacy Act. So you'd want to look at like 21 CFR 20 to see FDA's and other agencies. So there's kind of multiple layers there, and it isn't just the Privacy Act.
So I apologize for monopolizing time, but that really wasn't my question. My question was actually for Barbara, which I read your very interesting paper on genomics data and the price caps, essentially, that I guess it's the High Tech Act places on how much you can charge. And I know our resource panel is later, but since you're here and you're the legal person, so how much do you think that's going to impact the ability to charge for data? Because that may be, as you said, the market solution, I tend to agree, tends to be the one that works. And so, could you speak more about that? And, yeah.
The High Tech Act required some amendments to the HIPAA privacy rule, which were promulgated last January and went into effect in September. Basically, data cannot be sold, but I think there's an equivalence relationship between data and the capital a company invested to prepare the data. And what HIPAA does now allow is a reasonable cost-based fee for the cost of data preparation and transmittal. So if a company has tracked its cost of developing its data set, putting it in a common data model, doing IRB review and whatever it does prior to releasing it, those tracked costs can be recovered. The major issue that still is a gap that very much needs to be addressed here is that HHS did not allow a return on capital invested in data preparation and transmittal, which means companies that invest to do clinical trials and prepare their data to share it can make no return whatsoever on that investment, which is very disincentivizing. And also, we have 145 years of Supreme Court cases in other contexts that a cost-based fee that doesn't allow a return on capital is confiscatory and unconstitutional, but it hasn't yet been challenged.
One thing to that, which is that there is one exception to what Barbara's absolutely correct, but there's one exception, which is that you can charge for data if the person unequivocally consents to that at the beginning of the relationship. So this is something that in turn reflects back on the potential for so-called informed consent.
Okay, I have Steve, Ida, Tim, and Jeff. So Steve, you're up. Oh, and Bernie.
Okay, I'll ask it fast. So starting with Brad's point that nothing can be actually de-identified with certainty or 100%, it seems like the entire issue, and I'm just rephrasing what's been said, goes to both the probability of re-identification and the degree of harm. Now, one thing that's troubling about all the various overlapping legal structures, which now I'm even more bewildered than I was after Mark, who discussed all the international ones. Now we have to deal with all the state ones and overlapping federal ones, is they don't seem to take this into account except indirectly through this, 18 through the safe harbor provisions, but then they have this clause that you mentioned about other knowledge related to re-identification, but it doesn't specify a specific threshold. So how are we supposed to deal with all these? I mean, maybe we won't deal with them at all. All these privacy and protection statutes that don't seem to recognize or give us the ability to make any sort of reasonable calculus between the degree of probable harm, which is both the magnitude of the harm and the probability, and the benefit which the sharing can produce.
So that's the $20,000 question, right? That's one of them. I think that there's a problem in that. Let's take a step back for a second. You correctly mentioned that there's no threshold that is defined. And I can say that the Office for Civil Rights was asked to define a threshold, and they chose to not do so because they believed that would be policymaking at the time. And so that has not been done. To the best of my knowledge, there has been no group around the world that has actually defined an acceptable threshold, except for federal statistical agencies that and some states, public health agencies that tend to provide general counts. So they'll say, look, the risk of identification must be no greater than 1 in 3 or 1 in 10, because these things were derivative of the way tables were published by statistical agencies. And so these types of rules have been defined, and they've done that in it's the Federal Committee on Statistical Methodologies working paper number 22. It actually does show up in there, and it was originally written in the 1990s, and it was revised in 2005. So they took a stand. They consolidated some of that evidence, and that was a bunch of agencies within the state and federal groups that tried to provide some guidance. But this notion of what the calculus needs to be, this is a discussion that you need to have with the people who are sharing these data sets or intending to share these data sets, because you don't necessarily know what the harm will be up front, because there are no good cases. And that's why I was saying that there are no real good cases of data being re-identified and used against individuals. To the best of my knowledge, there's almost no case law around that, which begs the question, how do you go about defining harm from the outset if you don't know how it's going to be misused? That's a challenging problem. It's also one of the reasons why I say that in many ways, de-identification, while there have been demonstrations to show that, yeah, there's a potential for identifiability, that we may be way overprotecting the information in that regard, because there may be some type of a normal distribution of where things stand, and we're looking at one thing all the way out here. That worries me a little bit. But you can only find the appropriate calculus by talking to the data sharers. That's one of the first things I would say.
Can I give a legal answer to that? If you look at statutes, I mean, the statistical, the technical measures are certainly very important. If you look at statutes, there are a bunch of words found in a variety of statutes. I've summarized some of these in my writing, and they use all kinds of different standards. Older statutes, nobody even understood this issue, and they just use words. And then you look at statutes, and some of them talk in terms of how much information is available to the recipient of the data, or how much information is available in the world, how much capability somebody has, how much it costs. These are all, sometimes you find the words reasonable. There are just a whole bunch of different legal standards. There's a lot of evolution going on here. No one's quite sure, and the uncertainty reflected at the technical level is very much magnified in the legal standards, because they're just not very good.
Just one to follow up on this a little bit more. So I recently came off a committee that was looking at proposed changes to the Common Rule for the management of behavioral and social data. And one of the things that came out of that study, I can now say it because there was the public release on January 31st, was that this notion of data sharing and data protections in general, it's a patchwork in the U.S. still. and that one of the recommendations that had been made was consideration for some type of a centralized agency or organization that could provide this type of guidance. I think the Center for Democracy and Technology said this almost 5 years ago, and it keeps coming up over and over again. I will stand and advocate for that, because I do worry that this is not just a clinical trials problem when you're talking about de-identification. The unique component is that some of the data is extremely longitudinal, which you don't always see in a lot of data sets, and that does make it very interesting. But this notion of you should not be the group that is providing guidance on what that threshold should be. That should be something that is coming out of some type of a clearinghouse.
Let me just point out again, I mean, I'd said it this morning, but, you know, there is aside from the de-identification, and then there's another exception which we haven't, which Brad didn't really go into, but one could, which is the limited data set, which allows a few more things. It's sort of another kind of demi-safe harbor, if you will. But aside from that, just remember, there is a legal method, both under the rubric of research-informed consent and also under HIPAA, of waiver, by which an IRB or a privacy board, based on an application, based on an analysis of practicability and minimal risk, is allowed. There's a completely legal methodology, a window out, you know, a trap door that gets us out of all of this stuff. If an IRB is convinced that, or a privacy board is convinced that these are the appropriate mechanisms, and that's for identified data.
So I'm. You wanted to debate? I'm on camera. I would actually disagree with that. Okay. Because I think that would be useful for in-house utilization of the data.
Right.
But as soon as it goes towards the public-facing side, you're not going to get a waiver for the disclosure of information to the public.
Oh, I would agree with that. But all I'm saying is that there is a method right now that exists in law by which, though, if you can convince an IRB based on those values, then IRB has the authority to grant that.
Okay, I'm just, because we have several people waiting, including Trudy on the telephone, which we're going to let her go ahead and go. Trudy, are you ready?
Yeah, I'm ready. Can you hear me okay?
Yes, we can. Go ahead.
Great. Well, thanks. It's important to understand that we shouldn't ignore state law, and obviously HIPAA is of great significance. I just wanted to make my normal point that as a committee we seek to find recommendations that will be appropriate to trials conducted all over the world. And by this, of course, we don't just mean trials from the US or Europe that have got centres or sites in other countries, but trials that are led from elsewhere as well. I just wanted to ask any of the panellists if you have any views or experience of legal frameworks elsewhere in the world. Obviously in Europe we've got the conflict between the clinical trial regulations and the changes that are being made there, and how they conflict entirely with the data protection laws, which is a very particular issue in the EU. But obviously there's very many other legal frameworks elsewhere in the world. So I just think we need to broaden this discussion outside of the US. Thank you.
So Trudy, I don't know if you were present for some of the other presentations about other laws, but I'll offer the panelists a chance to opine. I think we probably defaulted to a HIPAA-centric conversation because of the de-identification standards that do exist in that law, but turning it back over to you, is there something we missed?
Well, I think one thing that's true both as relates to the nexus between U.S. federal law and the law of other countries, and then between federal and state, is that at some level one needs to go to the principles of what are the unique features of this sharing exercise you're discussing, and sort of perhaps take a normative approach of what should it be. And then with respect to the problem within the U.S., there are organizations you can try to get model data sharing acts that states would have and could pass, and I assume some of that to create a level of consistency between U.S. and other countries is a matter of just conforming and trying to do the necessary cleanup afterward to get laws passed that are more consistent. I'd like to hear what the others have to say.
I just make a very simple point that in the U.S., when you disclose data to a third party, privacy regulations typically do not move with the data, and in the hands of the recipient, the data is not protected. That is not the case in Europe, where there are broadly applicable data protection laws that apply to most record keepers. That's true in Canada, that's true in Australia. Most laws around the world are structured the way the European laws are, and they create a baseline of privacy protection for all data controllers.
Okay, so we're going to have to move into lightning round here. We have Tim and Bernie and Jeff. Ida, did you put your card back down? Did your question get answered? Okay, so 3 to go. Oh, okay. Bernie?
This is a question for Brad with regard to the right-hand box on de-identification, the expert determination. It's stage right, stage whatever, stage left. Questions quickly on feasibility. How much does it cost to do the analysis you did for Sanofi? How many other people are there who are really qualified in the sense that I think most of us would trust you? I could see a MPH graduate who I might not trust. Second phase, is there a way of constructing criteria that are, as a presumption, adequate for a certain type of clinical trial? So do you have to go through the analysis with each specific clinical trial, or can there be a more generic standard that applies to a class of clinical trials, specifying, for example, the size of the geographical area, the N of participants, and say even if you throw in an extra safety margin? I just wonder how feasible it's going to be, because it seems to me underused, this expert determination, and it's kind of a black box to people. So if each one is done on a ad hoc basis and not necessarily published, I'm just trying to, can this become more widely used and more accepted and understood?
Yes.
Okay.
Well, I ended with your last question. I'm just being facetious. How much did it cost? I don't know if I can answer that question off the bat.
Order of magnitude? 10,000, 100,000?
I still don't think I can answer that question because that's a contract with a private entity. And I can't speak on behalf of other companies as well.
Okay.
It's much smaller than the cost of the trial. We'll put it at that.
All right, so
It's as far as I can go.
Okay, let's leave that.
Let's
try and
turn
ask
towards
sponsors.
feasibility.
Yeah.
Towards feasibility. It's very feasible. I'm not going to advocate for a particular way or a particular book. I will say that Khaled El-Imam has actually published several books in the last 2 years detailing the methodology that actually is invoked by his company. This was a company that was a spin-off from the University of Ottawa. And they have been doing this for lots of different types of data, lots of different resources in different countries. In terms of coming up with a model, I think that there are models. I think that we've had discussions about this with various consortia of clinical trials groups in terms of what are the canonical types of clinical trials that are run, what is the structure, and then I think that we would be able to back out some very simple models that could be applied in that setting, and that if everybody agreed upon them, they would be useful. They would probably end up being pushed towards more protective than anything else. Right. But yeah, I'm pretty confident that they could be defined.
Can I add two very quick points? One is I leave it to others to decide about models, but I think methodologies here may be just as important as particular models. You know, what steps do you have to go through? Because there's no guidance in the rule. And secondly, while I think the expert provision in HIPAA is fine, not that it couldn't be refined some, but it also has the flavor of a hired gun to it as well. Just get yourself an expert, get them to sign off, and you can do whatever you want.
Bernie, for what it's worth, I have, on behalf of clients, procured services for the expert opinion, not from Brad, but from others. And in my experience, the magnitude, the range you're talking about is like 5 to 25,000 or 5 to 50. It's not 100. It's not 500. And of course, it depends on the data set, depends on the expert and everything else. But
That's
So recognizing that we're close to time, but do we have time for Jeff?
We always have time.
Okay, well, there you go.
Well, this is sort of a follow-up to Bernie's question. This isn't easy, right? To re-identify data. Somebody has to work at it to do it. It's not like somebody dropped their laptop on the street and they picked it up and suddenly all the data were there. So why isn't it just illegal to do this? I mean, if that's what we need to have happen, because we're having, we're saying, oh my gosh, these are terrible things and it's impossible to protect from them. So just make it against the law. You get caught, you get thrown in jail.
I mean, I think that's right. And I mean, that's what, Barbara Beerer and I and other people at MRCT have said exactly that, which is, if you want to do this, then you've got to have an enforcement mechanism that's effective for these data use agreements. And you've also, criminalize it. Criminalize the re-identification and the malicious use of re-identified data, right? Just criminalize it. That's the kind of thing, but it would have to be a national statute, and it would be part of a compact, in terms of this is what we're going to give in terms of the data sharing. These are your obligations as a research subject, patient, et cetera. This is the communitarian objective, but this is how we're going to protect you.
No, I agree very much with what Mark has said about the need to have enforceable standards. One of the difficulties, though, is detecting the violations. It can be very, very hard when a person's data become re-identified to the person's detriment to trace exactly where the problem occurred. And that's ultimately one of the difficulties with the enforcement mechanism is the audit. How do you detect it?
If I could just add, I've drafted a statute that would do this. It's really hard to do this generally, to say anyone who re-identifies data goes to jail. You're going to run into all kinds of line drawing problems, First Amendment problems, God knows what. The mechanism that I used was if you get data under a contract, then you opt into a system that includes all kinds of penalties, and that's a way of controlling it and making it legal.
Follow up on this. So as a committee, if we said that a goal was to try to find some way to make the re-identification of data something that you shouldn't do, or that we know that you shouldn't do, but that there were penalties for doing it, that would be of value. You think that would be of value, even though it may be difficult to draft such legislation and to find the people, but at least it would be a start.
I think it would make people cognizant that there are that they can be held accountable for their actions. Whether or not you can enforce it, that's a whole different issue. But the problem is that this is why these data sharing models are being wrapped with acceptable use terms more than anything else, but they're being defined in a very ad hoc manner. But just one other thing, I think the challenge here is in the management component of this. So who actually has oversight at this point? Do you turn it into something at the federal level, or do you turn this into something that turns into private settings? And those are two very different situations. Like criminalizing it is one thing, but this is a lot of times the data is not going to be disclosed from agencies that are in violation of a federal statute.
May I say one thing? Just putting a civil or criminal liability doesn't help the person whose data are breached. You also need some remedies that are accessible to the person who's the victim of that. So it's hard. You can't compensate the damage with money, but some thought to what they should have when their data are re-identified would be good.
I want to thank the panelists very much for sharing all of your wisdom and engaging in these conversations with us. We very much appreciate it.
Thanks. I echo those thanks, and thanks to Devin for moderating. Let's take a lunch break. There are box lunches out in the foyer, and let's try and reconvene at 12:40. Thanks.